You were going to, you asked leave of the court yesterday afternoon to do some additional research and to contemplate your position in this matter. What news do you have to bring to the court?
Thank you, Your Honor. And I thank the court for giving us additional time. As the court is well aware, it is our duty to examine all issues in a case. It's our ethical obligation to make sure that if any issues arise that may threaten an eventual verdict, we have to examine them whether we want to or not. And this was one that the court acknowledged was a difficult one. The serious issue of conflict was raised by the defense desire to play these tapes and present this evidence to the jury. And in pursuit of that, we did extensive research. This was the product of extensive discussion and hot debate. It was a very difficult and lengthy process, conducted over a number of hours last night and again this morning. And again, I appreciate the court's indulgence in giving us additional time this morning. Our position has always been, Your Honor, that we wanted a fair trial that would focus on the issues. We've objected from the start to the introduction of race because we knew it would skew the trial away from the evidence. And all our concerns have now been proven to be true. And now that all the defense efforts to present evidence of another perpetrator and police conspiracy have fallen flat and shown to be devoid of facts or evidence, they've turned to the N-word. And that's become the cornerstone of their case, admittedly. The prosecution team is made up of women and minorities, among others. We are all offended by the use of the words that we saw in these transcripts and heard on these tapes. We're also offended, however, by the efforts by the defense to manipulate a jury by injecting the emotionalism that has to occur, that occurs when we hear these things, into a case that should be focused on the evidence. Injecting this issue into this case, Your Honor, has hurt many decent people, yourself and us. I'm sure it will hurt the jurors when they hear it, if they do. But we have to proceed as lawyers and as representatives of the people. We have to consider that although we have not always agreed with the court, as advocates we challenge the court, yet we have always respected this court and its considerable talents and abilities as a very fine jurist. We want to end this case, Your Honor. We want to get a verdict from this jury. We don't want a mistrial. We want a verdict that's based on the evidence. We want a fair and just verdict. This case has taken its toll on everyone. Yourself, the lawyers, the taxpayers, the citizens, the families of the victims, the family of the defendant. And we have to be concerned with the public perception that these proceedings are conducted fairly, but we also have to be governed by our knowledge and familiarity with the considerable legal talents, abilities, and wisdom of this court. Although our review of the case law indicated that we are entitled under the law to seek the course of full recusal, we have determined that it is not the only course. And although the law does not expressly provide for a partial waiver of conflict, in consideration of all of the factors, Your Honor, we have decided that it would not be the appropriate course in this case. Upon weighing the apparent conflict and the defense desire to make these tapes the cornerstone of their case against the ability of this court to maintain its impartiality in the face of great temptation to do otherwise, we have determined that our faith in this court's wisdom and integrity has not been and will not be misplaced. Accordingly, we agree to proceed as previously delineated in this court's order that was issued yesterday. But the concern, strategically, practically speaking, Your Honor, is this. When the issue of conflict was first broached, it appeared to me that it could be a partial thing, that the tapes were a discrete segment that could be excised out and that we could proceed business as usual, as we have been discussing and the court is aware. It was further discussion that led to advice concerning, well, maybe you can't. Perhaps this is an all or nothing proposition. Upon further reflection, Mr. Darden and I conferred and determined that it really is, in at least one sense, an all or nothing thing, practically speaking. And here's what I mean, Your Honor. If another judge rules on the admissibility of the tapes, then Your Honor will have to preside with the witnesses that pertain to those tapes and implement that ruling without having heard the tapes and rule on objections concerning the testimony of those witnesses. Practically speaking, how can you do that?
Well, what I thought we had contemplated in our discussions yesterday was that should Judge Reed determine that my wife will not be a material witness or is not a relevant witness to the issues before the court, then that the court would review the transcript, a redacted transcript and a redacted tape. So the court would be familiar with the background and the context of the statements or any of the evidence that's on the tapes. So that's one alternative.
And it is. And I had thought about that, but the problem is the cart before the horse. You know, as the court has pointed out before, sometimes we raise these issues prematurely. But we will not know if Captain York is going to be a material witness until we know what's admissible, obviously.
I agree.
And even if she, and it may be that she's not material and she's just a witness, in which case I don't think we have a conflict situation, but that we can address later. It's not the problem. What we would like to do, Your Honor, is allow Judge Reed to continue reading and getting up to speed in case he has to make a determination as to the material witness status. But we think that Your Honor should review the tapes and determine their admissibility and make the rulings, because then you will be in the best position when the witnesses testify to rule on the objections, to narrow the scope or widen the scope as the case may be, because you will have ruled on the admissibility and you will be familiar with your own reasoning in determinations made as to what should come in and what should not. I can't see, practically speaking, any other effective way of doing this, because if you have another court's determination that you have to implement, I just don't see practically how that can work. I think the only appropriate thing to do is to, you know, like I said, I think that it really is an all or nothing proposition, and we are proposing all.
But don't you believe that it would be necessary for Judge Reed to make the materiality and relevance determination with regards to Captain York?
Yes, I do. That's why I said I don't think we've wasted time, Your Honor. He should get up to speed and read the transcript. I don't think that, you know, that you should be put in the position of making that determination. It can't be. But that is discreet. I can see that being discreet. You make the determination on the admissibility. You decide what comes in or what doesn't, if anything, and then we can address that issue. Judge Reed can see your order and make a full and informed decision as to whether or not Captain York is a material witness. I don't think that that decision can be made until we know. We may not even desire to call Captain York after we know what the ruling is. So we need to get that resolved first, and I think the court can do that. I think the court should do that.
All right. Thank you, Counsel.
Thank you, Ron.
Mr. Shapiro.
Yes, Your Honor. First, I'd like to respectfully request permission for myself, Mr. Cochran, and Dean Uelmen to address the court to put on the record what took place in chambers this morning, not as advocates, but as witnesses, so that we can have an accurate record of what took place, because we think this is crucial to the trial.
Well, at this point, Mr. Shapiro, rather than interrupt the argument at this point, because this argument fundamentally goes to the jurisdiction of the court to move forward. So before we launch into that issue that you're raising regarding our discussions in chamber, I would prefer to address the issue regarding this court's further participation in the trial.
Our position has been clear throughout. This court took a waiver last year. The first thing Your Honor did when you took the bench in this case is you addressed myself and Ms. Clark, and you said, I want the record to be absolutely clear, and I want Mr. Simpson to know that my wife is a captain on the police department. This could be a potential conflict. Are both sides aware of that and willing to waive it? So everything that they have done has been in bad faith. There is no way they can recuse you from this case. There is no way they can ask you to step down. There is no conflict. There's never been a conflict. And so clearly your order was correct. We have no problem with it. You've done it 3 times before. We've never heard an objection. We've been to 3 different judges on other sensitive issues that have been resolved by other judges without anything being said by the prosecution whatsoever.
All right, let me ask you one question then, Mr. Shapiro. What Ms. Clark proposes is a modification of what occurred yesterday. She's asking that Judge Reed conduct the hearing regarding the materiality and relevance issue regarding Captain York. It always seems strange to refer to your spouse in the third person. And then leave for this court the issue regarding the admissibility of the tapes themselves or portions thereof.
May we just have a moment to confer? Have a moment to confer. Thank you.
Be more comfortable if I left the bench and you had a time to talk about this?
No, we'll just take a second. It's all right. We're almost done. It's no problem.
All right.
If you're not inconvenienced to you, it's no problem.
Your Honor, we would like to, after this issue is resolved, put the issue that I asked to address the court about on the record, and I'd like Dean Uelmen to give our thoughts regarding the proposal that has been presented.
All right.
Would that be acceptable?
Yes.
Thank you very much.
I think it's very useful at this point to kind of step back and make sure everybody has a clear understanding of precisely the procedural posture of what's going on here and what is now being proposed. We did not perceive what happened yesterday to be any sort of judicial disqualification or even partial disqualification. What we understood was going on was the court referring to another judge the determination of whether a disqualification would be necessary. And it's not the first time that that was done in this case. It's the third time. And on every prior occasion, if there was any suggestion that what was being done required a complete disqualification of the judge from this case, that issue should have been raised at that time. And it's our contention that you can't sit back and have this procedure go on time after time after time as issues recur, and then when you see it as some sort of tactical advantage, raise the club of a total disqualification. So we believe any question of disqualification has been waived, and any question of total disqualification works some estoppel against the prosecution for not having raised the issue before. So from our perspective, this whole issue of total disqualification is a red herring. And it's, we believe, being used as a tactical ploy. And that issue is going to be addressed by Mr. Shapiro and Mr. Cochran in the light of what happened in chambers this morning. What is now being proposed is essentially what we were proposing initially yesterday and was contained in Your Honor's first draft, I believe, of the referral of the question to Judge Reed simply of whether Captain York will be a material witness in this case. And that is a satisfactory resolution of the issue for us. We believe that that issue can be decided with dispatch by Judge Reed. We believe there is no reasonable possibility that Captain York will be a material witness in this trial or need even be mentioned in this trial, because what we're going to present is an offer of proof of specific portions of that transcript that are directly relevant to the credibility of Detective Furman. 30 specific references in which he uses the word nigger in a racially offensive context and in which directly contradicts the testimony that he presented under oath in this courtroom. And we will present an additional 17 extracts where Detective Furman speaks with approval or with personal experience about police misconduct, the planting of evidence, the commission of perjury, and the presentation of cover-ups and false testimony in court proceedings. And then finally a reference to his own role in the proceedings before this court. So we're going to have a very limited offer of proof that can result in the redaction of a lot of other offensive material. And believe me, not just offensive to Captain York, but to every person who sits on the city council in Los Angeles, to every member of the ACLU, to every judge of this court. And that doesn't have to be even mentioned in the course of these proceedings. Frankly, I think we're back to where we started yesterday, to simply send to Judge Reed
that way, doesn't it?
the question of whether Captain York will be a material witness.
All right, so you accept?
We accept a referral to Judge Reed of the question of whether there is any reasonable possibility that Captain York will be a material witness. And leave to the decision of this court the materiality of the offer of proof that we will present with respect to particular portions of the transcript that we propose to offer in evidence. Could I have just a moment?
Certainly.
With respect to the other issue that I mentioned, that is the motivation for what has gone on, I'd like to turn the microphone back to Mr. Shapiro.
Let me finish the issue of what it is we're doing first. All right, Ms. Clark.
Thank you, Your Honor. I'm very concerned by the spurious and unfair allegations made by counsel and now alluded to. That's why this case has gone on this long. You know, we have press conference after press conference, in the court, out of the court. I think that the point here is that we had an ethical obligation to examine issues that could be serious, that could have threatened the integrity of any verdict we ever got. We could not anticipate this conflict. No one could, Your Honor. No one knew about these tapes. No one, not even the defense, until the 11th hour. When we were apprised of the fact and learned of the contents, we immediately began to address the issue that seemed to be raised. We don't have the luxury of burying our heads in the sand and pretending issues don't exist like the defense does. As officers of this court, as representatives of the people, whether we like the issue, whether we like the outcome, a result of the legal issue, whether we like the answer to the question or not, we are compelled. It is our ethical duty to answer the question in the appropriate manner that will protect the integrity of any possible verdict. And that's what we have done. And we've made our very best effort to examine all of the case law and make sure that the course we adopt is the correct one, the sound legal one that will preserve the integrity of the judicial system and of any verdict that we may obtain in this case. That's all we have done. And defense wants to somehow indicate that there's a tactical decision being made here in raising the conflict issue. I mean, that is the biggest bunch of nonsense I've ever heard. The court eloquently stated what the problems were. And I looked to the court's own remarks yesterday in its order, in which the court stated as follows: would a reasonable person entertain a doubt concerning this court's ability to impartially decide the scope and availability of impeachment evidence concerning a witness who has specifically referred to the court's spouse in a disparaging manner? Is it possible to conceive a scenario where a court similarly situated would be tempted to punish Furman by broadening the scope of impeachment? Is it possible to conceive of a scenario where a court similarly situated would be tempted to narrow the scope of impeachment to prove impartiality? The reasonable answer is yes. Those were these court's own words. The court obviously saw the problem that was posed by the situation we're placed in with the introduction of these tapes. No one can ignore it. The defense would like to ignore it. Mr. Cochran, back in chambers, was gleefully referring to these passages involving Captain York in the very hope that Your Honor would be biased, would be inflamed, and would seek to punish Detective Furman for having made those comments. That was the tactical advantage they hoped to gain. Unfortunately, what they did not foresee is that the very tactical advantage they hoped to capitalize on spelled bias under the law, spelled conflict under the law. Not the real, obvious, actual bias, but the kind that we have to be concerned with under the law, the apparent bias, the appearance of impropriety. Counsel didn't play that out. He didn't think about the import of what he was saying. We have to. We have to think about this. We have to think about what are the consequences if no one addresses this issue. Now we have. The defense has addressed the issue, we have addressed the issue, and we are convinced, in having examined all aspects of this, we have always been, first of all, let me just say one thing. We have always been convinced of the court's ability to be fair and impartial, even in such a trying situation, even though the temptation for all of us would be tremendous not to be, one way or another. We have faith in this court's ability to do so. We know the court will do so. But what we have to be sure of is that the record is absolutely clear, that there can be no later appeal by the defense saying that there was a conflict that they never waived. Now it's waived. Now it's clear. We have a very clean record that cannot be assailed on appeal should we ever get a conviction in this case. And that's what we have to do as officers of this court, as representatives of the people. We are responding to counsel's desire to gain a tactical advantage in this matter, to counsel's desire, as unsophisticated as it was, an effort to get the court to behave in a biased manner. We know the court will not do so. But having injected such an issue into the record, we also had to be sure that no one would ever question the people's decision to have this court make the decision in this matter. And now we know that it cannot be. With respect to the Chamber's conference, Your Honor, I think that I was...
They always try to...
Hold on. Have a seat, Mr. Shapiro. Mr. Clark, I want to resolve and make a ruling on the issue that we have before me. Mr. Cochran did ask first to address that issue.
Okay. And, Your Honor, all I was going to say about it is...
Yep.
All right.
I'll let you respond.
Okay.
All right.
Thank you.
As to the issue regarding the referral to Judge Reed, it appears to me that both parties have agreed that this court should issue an amended order directing Judge Reed to evaluate the tape recordings and the transcripts of these proceedings previously with regards to Detective Furman, and to make a determination whether or not Captain York will be a relevant or material witness in this case. And that is the issue that he is to determine. That once that has been determined, if Captain York is a relevant and material witness, then this court has no other alternative but to completely recuse itself. However, if that is not the case, then the agreement between the parties is that a redacted transcript and tape recordings will be submitted to this court for this court to make the determination of admissibility of any impeaching materials, any of these 30 uses of racial epithets, any of these 17 incidents that are alluded to, or any comments regarding current attitude towards testifying. That's my understanding of our position.
That's the problem, Your Honor, that we have, is that I don't think the determination can be made as to whether or not Captain York is a material witness without knowing what's admissible first. You know what I mean? It's kind of putting the cart before the horse. We need to know what Your Honor is going to admit into evidence before we know whether she is a material witness. She may not be after the ruling, or she may be, but we cannot know that until the court determines what's admissible.
Then wouldn't the easiest way to do this would be for me to have the redacted
That's right.
tape
That's right.
and transcript, make that resolution first, and then refer the matter?
Also,
Right,
Your Honor,
exactly, Your Honor. I mean, that's what the people are proposing, is that we give the court the redacted version, let the court make its ruling, and then let Judge Reed, and Judge Reed should be getting up to speed during this time. This will give him the opportunity to do so, and after then he should have the court's ruling as to what's deemed admissible. He can read the unredacted version and see whether in his determination she would be a material witness. But I did want to point out one distinction, if I may, Your Honor, and that is that there's a distinction, I think, in the law with respect to conflict as to whether she's a material witness or just a witness, I think. And obviously, we will brief this out, but if we determine that we'd like to call her as a witness, yet she is not material, because frankly, this whole issue is not material, then I don't think the court needs to recuse itself.
Judge,
Well,
one other thing.
that's an issue that we're not
No,
close
we-
to at this point.
I think that Jerry wants to address part of
I've
this.
never heard of calling an immaterial witness, but the profit that will establish the materiality of the redacted portion of the tape can be presented to both this court and to Judge Reed. And assuming, I think our position is, even assuming that all of the redacted portion is deemed material, Captain York is still an immaterial witness. And I think Judge Reed can make that ruling just based on the proffer that we are offering of what portions of the tape we intend to offer.
But that ignores issues of 356, Your Honor. You know, you can't put that horse before the cart before the horse that way. If perhaps the defense wants to admit some passages that we think need to be balanced or placed into context with something else, then Judge Reed is only getting half a look. He's getting what the defense wants. You know, as much as they'd like to have this a one-sided lawsuit, it's not.
Well, no,
There's-
you would have the opportunity to present your countervailing points and authorities, and I'm sure Judge Reed will entertain argument on the issues, but I think the point that you raise, that this court should determine which of these multiplicity of incidents that the defense wishes to offer, the court should determine that first before Judge Reed launches into that. But he should also start looking at this stuff, since it appears to be voluminous, and he needs to do a lot of background on it. So I'm willing to do that. So when, Mr. Cochran, when can you make available to the court a written proffer with regards to each one of these incidents and the factual materials, the tapes and the transcripts? And then obviously the prosecution will have the opportunity to submit points and authorities in contravention to the admissibility or materiality of those issues. And then I'll hear argument as to each individual incident or use time as after I have familiarized myself with the proffers, the opposition, and the actual underlying material.
In answer to your question, Your Honor, I would anticipate we could have it ready by 9 o'clock tomorrow morning. So we want to move ahead because we're at that point in the case once we finish with this witness. One other thing I was going to suggest on this issue, Your Honor, is that we have two declarations from Captain York, and I think that they may be helpful to Judge Reed, and these are declarations
That's part of the
under
record.
penalty of perjury. And I don't know if you've sent those, but I think they should be sent because I'm telling you, the people have never talked to your wife, I'm sure, and so this is like fantasy land. So we have actual declarations from November 21st, 1994, and both from November 21st, and I think it would be helpful if those are sent along also. That's all right.
Mr. Cochran's mistaken, because I did speak with Captain York when she appeared in court.
No, I mean, have they talked to Captain York since these tapes? They're talking about being material. You have to talk to a witness before you make that determination. Now, will the court hear now from us on the other issue? Cheryl first.
All right, Mr. Shapiro, actually, I'm sorry. I still haven't, since I've gotten controversy as to what's going on here. All right, let me just determine what will happen at this point. All right, we will proceed as follows. The defense will submit to the court its offer of proof with argument with regards to each of these incidents, plus the redacted tape and transcripts supporting tomorrow morning. After that has been filed, the prosecution will have the opportunity to file any written opposition that it wishes to, and after the court determines what's here, I'll schedule an argument with regards to each one of these incidents. All right? will instruct Judge Reed, or request Judge Reed, since he is a judge of equal stature, I'll request Judge Reed to confine his activities to the issue of the relevance and materiality of Captain York's testimony, but he will have also available to him the whole constellation of the record, the tapes, and the full transcript, and the benefit of any points and authorities that either side wishes to submit. And I'm certain that Judge Reed will also entertain oral argument with regard to the issue, but that is something further down the road.
We may never reach that. You know, we just don't know at this time. I was
All
going
right.
to only urge that the court proceed to review all of the tapes and transcripts without waiting for points and authorities, because there's a lot.
Well, I'll do my best.
Judge, one other thing from a standpoint is the court is aware we brought Ms. McKinney out to California, and this is a matter of scheduling. I understand the time constraints. She has a family, and it seemed to me, and of course, give me an estimate without rushing anyone. There's going to be some downtime, obviously, less than what we thought at the end of yesterday, but some downtime. And I want to be able to represent her to her that she can go back home or whatever. When do you think we'll get to the hearing, like 402 hearing at the earliest, assuming that this is...
Well, having never seen any of these materials, you would actually be in a better position to tell me.
Well, I think Your Honor is a hard worker. You can cover, you can get through these tapes. You know, because it's like Lay's potato chips. You can't put them down. You can't eat just one. Once you start listening, you're going to have to keep on going. But given your other constraints, you have other things to do. So I understand that. So you can get through the tapes in 12, 13 hours. The question's going to be, Your Honor, we're going to brief it, give you the proper, they get to brief it, and there'll be arguments back and forth. And, you know, she's been out of here, you know, since Sunday. So the question is...
Well, counsel, today being Wednesday, I think it would be overly optimistic to expect that this court would be able to entertain argument on the matter much before Monday of next week.
Okay, that's just a general estimate, and I'm not saying, I want to be able to give her an option if she wants to go back or whatever. That's not good.
Okay.
So I think that's probably a realistic appraisal that we can.
And the problem is Judge Reed has the only copy of the tapes that's been proffered to the
Well,
court.
we can give you, we can this afternoon, we'll have a copy for you this afternoon. Or that copy, yes. That one.
All right,
And we would like a copy of anything given to the court. We want to...
done. All right. All right, we're clear on that. Now, as to this in-chambers issue, counsel, I'll entertain your comments for 5 minutes. I realize you want to make your record. I'm going to restrict this, however, to one speaker per side.
Thank you very much, Your Honor. Your Honor heard this morning from Ms. Clark about ethical responsibilities and why they had to pursue this remedy and approach you like a doctor would a patient who had a malignancy and say that we may have to go for a complete recusal. That was behind your back. That was done in front of Judge Reed after they knew you had sent it out for a limited purpose. But the true reason of why they sought your recusal came out in an honest and frank discussion by Mr. Darden today in chambers. Mr. Cochran was present, Dean Uelmen was present, I was present, Ms. Clark was present, and Mr. Darden was present. We wanted to be on the record, they wanted to be off the record. You allowed it to be off the record. We find in hindsight that was unfortunate. Mr. Darden sat next to you at your desk and said, adjacent to you at your desk, be a better,
Everybody sits on the other side.
be a better term,
Yeah.
more accurate term, and said, you seem to be in a better mood today, Your Honor. And
It's because I had all the transcripts packed up and ready to go.
that's correct, and you pointed that out to him, and you said you were ready for your vacation, which is long overdue and well-deserved. He then, however, got to the heart of the matter. He said, Judge, I haven't vented in a long time, and I'd like to vent. We think you've been unfair with us. We think you've been unfair to the prosecution. It started with Mr. Kellberg. You cut Mr. Kellberg off. You allowed Mr. Cochran 6 days of cross-examination, and you would not allow Mr. Kellberg cross-examination. You embarrassed Mr. Kellberg. You ridiculed him in front of the jury, and we don't like that. You also continued to do that the next day with Miss Clark. You cut her off. You vilified her in front of the jury. We don't like that. And that was the reason that they had threatened this recusal against you. And Mr. Cochran, with control, became so indignant, as did I and as did Dean Uelmen, that we literally stormed out of your chambers. And for that we apologize, but it was not an affront to you, but rather that we were so taken back by what amounted to prosecutorial extortion of the judiciary that we felt that it had to be addressed and had to be corrected immediately. Mr. Cochran made certain comments that what the prosecution did warranted being referred to the state bar for unethical conduct. And that is going to be our intention for an investigation as to whether or not they have attempted to obstruct justice in chambers by putting you in an uncomfortable and untenable position that you have been unfair personally to Ms. Clark and unfair personally to Mr. Kellberg. We find that reprehensible. And we are going to have this record clear and make sure that a complete and thorough investigation takes place as to what took place in your chambers this morning. But fortunately for Mr. Darden, he did tell the truth. He told you what the reasons were. He told you why they were unhappy. This was payback time, and we've seen it before. Mr. Bosco told us about it from the witness stand, and now we see it. We've seen it with Dr. Golden, that if they don't go along with their theory, they'll come in and destroy him. And the same thing was attempted with you. And we want the record to reflect it. We want the record to reflect our absolute and unequivocal and joint feelings that this is unethical conduct at its highest, and that we will pursue all remedies that the law allows. May I just have one moment? The implicit message was, we're sending you a message. And in fact, I related this to Your Honor as I was walking out of the courtroom, out of your chambers. And I said, they want to play with their ball, on their field, with their referee. And as soon as you disagree with their decision, you're out. And they were sending you a message, a loud and clear message, that after you've told long and hard for a year on this case, that you could be out overnight. And they were going to tell you they were unhappy. Ms. Clark put it on the record the day before. I'm very unhappy with you, Judge. I've never been treated worse by any judge or any court. We all know that's not the case. We all know that at times you do get exasperated, but I think you've shown great patience to all of us. But you've come down hard on members of the defense team. You've come down hard on members of the prosecution team. And many times we have all acknowledged that it was well-deserved and sometimes too late. But to come into Your Honor's chambers and to invade the sanctity of judicial independence and let them know in the middle of a trial, at the end of a trial, that they are displeased with you and the way they are being treated is unethical conduct. Thank you.
Thank you, counsel. Mr. Darden?
Your Honor, I'm so offended at Mr. Shapiro's remarks that I'm sure that are being fed to him by Mr. Cochran. But I'm so offended by those remarks that I would rather not stand at the same podium at which he stood a few moments ago. For a year now, these defense attorneys have been holding over your head the issue of Captain York and Detective Furman. It's extortion. It's been a year-long extortion attempt by the defense to get you to allow as much racist and irrelevant and inflammatory incidents into this trial as possible. They've known about Detective Furman. They've been talking to a retired police officer named Mr. Evans all year. They knew about encounters supposedly had between Captain York and Detective Furman. They knew all about that. But rather than just front all of that and tell you and tell us and tell all of us about some of the issues concerning Detective Furman, they decided to wait until the end of the case. When they talk about unethical conduct, I think it's unethical to present a defense that is based completely on mistruths, lies, and deception. And that is what they've done throughout this case. I think it is unethical for counsel to hold press conferences in this courtroom and downstairs on the first floor and tease the public and tease the media by throwing them bits and pieces of the contents of these tapes, arousing the public, arousing a certain element, or certain parts of the public, inflaming their passions in an attempt to exert political pressure over you, in an attempt to pressure you to admit, into this case, the Furman tapes, tapes that are largely, if not completely, irrelevant to the issues at hand. The issue here is Kim Goldman, Patty Goldman, Fred Goldman, and the Brown family. The issue here is whether this defendant killed Nicole Brown or Ron Goldman or not. The issue here isn't my ethics. The issue here isn't racism. The issue here isn't Detective Furman. And it isn't their egos and how much money they can make or how many talk shows they can appear on. This case is a circus, and they've made it a circus. And I know that you've tried to do everything you could to prevent that. And so have we. Now, if Mr. Shapiro and Mr. Cochran want to refer me to the state bar, fine, because when this case is over, I'm going to be referring defense attorneys to the United States Attorney's Office. And he chuckles now, but will he be chuckling later on? It won't be so funny later on. They don't know everything that I know. You know, back in February, you and I had, for lack of a better term, a run-in. I think it was February. And I apologize to this court for my conduct. And I am not above apologizing, Your Honor. I have no apology to offer to this court or to the defense for my comments this morning. When we were here back in February, and after my apology, I asked your permission to speak with you on those occasions when I felt that there were issues that you and I should talk about. You know, that I'd be allowed to vent on occasion. And I think the defense made a similar request of you at some point, whether it was on the record or not, because I know that we have all gone into chambers off the record and complained. They complained about the fine you gave them for the discovery violation, off the record. They complained about the fine you gave Mr. Neufeld, off the record. They complained about the manner in which they were treated by you, or they complained about rulings, off the record. We raised the issue of bias because we're compelled to do so under the rules of ethics that apply to attorneys, because we are prosecutors, and because the Code of Civil Procedure requires us to do that. I'm sure the court noticed that Ms. Clark read from a prepared statement this morning. When I went into chambers this morning, I went into chambers to vent, to complain to you that I did not appreciate the manner in which Mr. Kelberg and Ms. Clark was treated before this jury by the court. I feel like I have that right. I mean, if I don't have that right, Judge, just tell me. If I'm out of line, just tell me. Just tell me to sit down and shut up, and the court has in the past, and I've done just that. But the court granted me that privilege. But I wanted to complain about that. I wanted to complain about them and their press conferences in this courtroom. I have sat here and listened and endured that for the last 12 months. I shouldn't have to. The public shouldn't have to. This is a court of law. I wanted to inform the court of our position on the recusal issue. I wanted to discuss with the court how it is that we were going to handle not only the Furman tapes, but the witnesses that relate to Furman as well. If there is an issue of bias as it relates to Detective Furman, is there also an issue of bias that we have to deal with as it relates to witnesses who might also impeach Detective Furman? I came into chambers to try and hammer out some of the issues that are confronting us so that we can continue with this trial, convict this defendant, and so I can get on with my life. And if there's something wrong with that or unethical about that, well, I'm sorry. The manner in which I was treated by Mr. Shapiro and Mr. Cochran this morning, it was that type of conduct that I was there to try and prevent, Judge. I wanted to complain to the court about the constant run-ins and confrontations between the prosecution and the defense. What I was extending to the court and to the defense counsel this morning was an olive branch, but what I got in return was something else. I have always acted in an ethical manner before this court and before every other court, I'd like to think, and I think I have a reputation for being fair, even as a prosecutor. I think I have that reputation in all communities within this county, Judge. And if they want to refer me to the state bar, they can line up behind all the LAPD officers that I investigated and prosecuted for perjury and for planting evidence and for lying and cheating. They can take a number. Yesterday when we went to Department 100, I saw something that I hadn't seen in a long time, Judge, and I wanted to bring this to your attention. I saw Judge Basque shut Mr. Cochran off. Mr. Cochran made a few remarks. Judge Basque told him he wasn't interested in that. At the completion of those remarks, he said to Mr. Cochran, submit it. Mr. Cochran said yes. And the next time Mr. Cochran attempted to rise again and address the same issue over and over again, as he is prone to do, the judge cut him off.
All right, Mr. Judge, would you wind it up?
I'd like to see that happen over the next month, if possible at all, Judge. And that's another issue I wanted to bring to your attention. I'm sure that I did not offend the court, and so that the record is clear at no time did I ever tell Your Honor that the reason we raised the recusal issue was because we were dissatisfied with the court's treatment of our lawyers. Isn't that correct? I thank you for your time, Your Honor.
Right. No, I've given both sides the opportunity to vent their positions and to make their record. And I've...
Mr. Cochran was personally attacked, and I would...
Well, counsel,
I'd like the court to at least let Mr. Cochran respond.
Now, counsel, this is an extraneous issue. If you feel you need to take remedies beyond this court, you're entitled to do so. Discussions between counsel in chambers, oftentimes off the record, oftentimes venting both sides. And, you know, I try to go right down the middle here. And the fact that we've got people on both sides, I mean, Mr. Neufeld, my recollection was Friday that he was outraged at the way I cut him off at the end of the day, and he wanted to make a record, and he was angry. Same thing happened to the prosecution. But at some point in time, these things have to come to a conclusion. And at some point in time, we have to recognize the fact that we have a jury that is way overdue as far as the time that they were told that they would have committed. I'm very concerned about the durability of this jury as they sit. And my primary interest at this juncture is to get this matter to the jury for them to decide. And on Friday, I told counsel on both sides in no uncertain terms, on the record, that the extraneous stuff needs to be closed down early, that we need to concentrate on the facts and circumstances of this case, and that we need to proceed to a judgment by this jury in this case. All right. Counsel, I have the jury over at the hotel because I had no idea what was going to transpire this morning. It is now 10:30. My proposal is that we come back at 1 o'clock and start with Michele Kestler, and I apologize to her for having canceled all of her medical appointments.
Your Honor, just if it's possible, there are a couple of preliminary questions with respect to Ms. Kestler that I'd like to resolve before she takes the witness stand and resumes the witness stand. I can do it now. I can do it in an hour if you'd like. In light of what's just transpired, it's up to you. But I would like to spend at least 5 minutes of the court's time dealing with some preliminary matters with regard to the witness.
All right. Who is going to be presenting the, Mr. Darden, is Ms. Kestler your witness? All right.
I can now?
Mr. Neufeld.
First of all, Your Honor, with respect to Ms. Kestler, I would like the court now, once and for all, to consider her an adverse and hostile witness. As you may recall, and I think both for subjective reasons and objective reasons, as you may recall, there were maybe 4 or 5 instances during the first 15 minutes of the direct examination where I had to ask the court to strike her examination, strike her answer as being non-responsive. On at least one occasion, you granted that request. There was no question that she was not necessarily cooperating with my questions and being totally responsive in that regard. And I think that was very clear from her demeanor as well.
So you're asking for the opportunity to ask her leading questions.
That's all I'm asking for at this time, Your Honor. Also, I think there's no question, given her role as the head of the SID, Criminalist Laboratory in this case, which has been attacked by, as part of the defense theory of the case throughout these proceedings, there is no question that she has an adverse position to the defense in this matter. Moreover, on a very subjective and personal level, she, during the July 13th interview with her, acknowledged her resentment toward the defense and toward, you know, what had happened so far between the defense allegations and the laboratory that she is responsible for. And so I believe that it's totally appropriate at this time.
Next issue.
Okay. Your Honor, a few minutes ago, you mentioned that on Friday, I went into chambers and I expressed I wanted to make a record after the court said that it felt that I lost track of the day. Monday, thank you. On Monday afternoon, how the court felt that the examination of both readers at this point in time and also the direct examination of Ms. Kestler were not very probative and not very useful, were extraneous, and should be dealt with accordingly. And what I wanted to say, Your Honor, in that regard is, first of all, you have to recall that the issues about the quality of the work of the criminalist in this case has been a very important portion of the defense theory of the case. We're talking about contamination and corruption of the evidence by members of that laboratory.
So why don't we get to that? Because asking Michele Kestler if she recollects meeting with particular individuals over a year ago, whether or not she took notes at those meetings, et cetera, is fascinating testimony to see what her recollection powers are. But the issue is, did she look at some of this evidence? Did these issues occur to her? Has she taken some different steps since this case started to reevaluate whether or not, for example, they ought to put swatches in plastic bags? Have they reevaluated that policy in light of what's happened here? Have they decided to retrain their individuals regarding blood collection? There's a lot of interesting stuff that she can talk about. She can talk about the fact that when she looked at the sock for the inventory purposes, didn't see any obvious blood staining. There's a lot of very practical, relevant stuff you can ask her. But whether or not she remembers meeting with 2 other individuals a year ago and who took notes or what it was about, if you look at the jury, they're looking at you, they're looking at the witness, they're looking at me going, what is this about?
Well,
That's my point.
You know, actually, it's funny, and that's the subjective impressions of the jury. Other people who I spoke to after who were watching the jury felt that they were looking, but not with that reaction, but rather looking at the witness, rolling their eyes at her answers, which they thought were pretty incredible.
Well, you can interpret that 2 ways. They're rolling their eyes saying, what does this mean? Why are we doing this? This is ridiculous. Or
I agree. We can all spend our days reading tea leaves, and I'm not going to do that. But what I do want to say, Your Honor, and the reason I had to ask those kinds of questions, for instance, is the witness was very resistant in even admitting that she had any kind of hands-on involvement in this particular case. And you know, for instance, from just the things you were just saying, that she did have some hands-on involvement.
so why don't we get to that?
Well, I'm going to, but I wanted to at least elicit from her and demonstrate that from the very first day, she was personally participating in the meetings that made the important decisions about this case.
Then why
and
don't
she was
we
giving
ask
me a difficult time even on
Why
that.
don't we ask her that question? Did you participate in a series of meetings at the beginning of the investigation of this case, and did you have some overall supervisorial responsibility? That's a compound question, but it's only two questions.
Okay, but the problem was is when I asked her about the meetings, and then she said no, and then I tried to move off of that, Mr. Darden objected, saying it assumes facts not in evidence, because she wasn't even acknowledging her participation or presence at the meetings. But anyway,
Mr.
that's...
Neufeld, she's the lab director.
All right. I understand that.
Okay.
And the last thing I'd like to say, Your Honor, and in that regard, is I am somewhat concerned when the court expresses its either impatience or whatever feelings it has about a lawyer's examination, be that lawyer myself, be that lawyer Ms. Clark, or anyone. And what I would simply ask, Your Honor, is other than ruling on those objections, if you do have that kind of concern with what I'm saying, what Ms. Clark is saying, or any of us is saying, that we do that at a sidebar.
Well, here's the problem, counsel. As a matter of judicial philosophy, I have always preferred to let the lawyers try their cases because I don't presume to know what it is you're trying to prove. I assume you know what you're doing. But at some point in time, if it doesn't make sense to me, and I've tried to pay close attention to everything that goes on in this case, if it doesn't make sense to me, I have the impression that it's probably not going to make a lot of sense to the jury. And I'm trying to encourage you, and you'll notice most of these exasperating comments that I make come late in the day. All right, I'll consider that.
Thank you. Now on a very specific basis, okay, issue. One of the things I'm going to be going into with this witness is she personally collected evidence on August 26th from the Bronco. But you made a ruling in this case early on that the luminol testing is not admissible. I don't intend to go into it. In fact, I told Ms. Kestler that if I mentioned the fact that she collected, if I listed from her the fact that she collected items of evidence from the Bronco on August 26th to evidence her own personal involvement in the criminalistics aspect of this case, that she's not to bring up the luminol testing. She can simply say, we were there to do other tests or whatever. And I just wanted to put that on the record at this time to make sure it doesn't come out, and to make sure also that by me asking her about her going to the Bronco on August 26th and actually collecting a blood stain from one place or coins or other trace evidence, that doesn't open the door to the prosecution going to the fact that luminol testing was done on the Bronco. So that's one substantive matter that I do need to resolve right now before I continue with my direct examination.
All right.
And I believe that would be the only item of substance that needs to be resolved.
All right.
Thank you.
Mr. Darden?
On the issue of the luminol testing, am I understanding Mr. Neufeld to say that there should be no mention of samples
Well, the
obtained?
court, I don't know specifically which parts of the Bronco console or whatever it is, which of the swatches that we're talking about specifically, but the court's ruling was pretty clear. If there are no confirmatory tests, that presumptive test doesn't come in. So if he carefully frames the question, that's the status of the case. That's the law of the case.
Okay, so basically the rule then is that there's no mention of luminol testing. I don't want the witness to be precluded from explaining her reasons for seizing certain stains.
Well, let's see how the testimony goes. I mean, obviously, the point he wants to make is that she was personally involved in evidence collection.
And that's the extent of it.
That's the issue.
Right.
Okay.
Okay. On the issue of Ms. Kestler being an adverse witness, by the way, Your Honor, you know, the court saw Ms. Kestler, Mrs. Kestler, and you watched her demeanor. to declare every witness who happens to work for the LAPD as some kind of adverse witness, I think it's unfair and it's unnecessary. I was objecting during the direct testimony because counsel was mixing apples and oranges in terms of her responsibility and participation during the time that she was assistant lab director in June and July, and when she subsequently became the lab director after July. Her duties changed. The questions he was asking were vague. They were vague to me, and they were vague to her as well, and that is why I was making the objections that I was making. At any event, if anything, Ms. Kestler gave more answer than the question required. It didn't appear at all to me that she was being reluctant at all, or if she was hiding anything, or if she harbored any animus toward Mr. Neufeld. The LAPD SID lab has opened, they have opened the lab on days when it is normally closed for the defense. They have closed the lab on days when it was normally open for the defense as well. They've made all of their employees accessible to the defense to be interviewed. Everyone that they've asked to interview has been interviewed at her direction. I mean, how can we now declare her an adverse witness? I have a real problem with her subsequent remedial conduct in terms of her having changed policies and stuff after June 13. I have a real problem with relevance on that, but that's another issue. And as far as Mr. Neufeld's mentioning of perhaps the court should take us to sidebar to straighten us out on those occasions when the cross has gone on a little too long. That's what I was trying to get at this morning, and we agree with that.
And I have done that on many occasions, invited you over without the court reporter, encouraged you to move along.
Okay. And we appreciate that, but I think we would all like to see those issues handled that way as often as possible. And I should say that I don't consider Mr. Neufeld's mentioning of that issue before the court this morning as some type of form of unethical conduct as well, Your Honor. But I would strenuously object to Ms. Kestler being described as an adverse witness at this point, Your Honor.
All right.
Your Honor, just one point. Number one, when I mentioned what I would like to see happen prospectively, I did not mention it in the context of some motion that I was about to make to the court, asking you, changing our position 180 degrees and saying, now we want you to consider the admissibility of these tapes.
No,
after
counsel.
All right, the other thing, Your Honor, is...
Let's talk about this issue.
Okay, fine. What I said about handling this at a sidebar, I said on the record in open court. I didn't say that it should be done in the robing room, in chambers, off the record. There's a big difference.
Are you interested in any of the other issues?
The other issues, I think, have been addressed.
All right, thank you. I will allow some limited leading of this witness, depending on the situation.
One other issue, okay. The court instruct counsel to seek the court's permission before
Yes.
leading the witness?
Yes.
May I raise one other issue?
Yes.
The issue has to do with the so-called jury view.
Yes.
We've been tied up with other matters, as the court is aware.
Your Honor, I'm sorry to interrupt, Mr. Cochran, but can we have the lawyers who went to the viewing down here to discuss this issue?
Okay.
Just before you do that, let me just indicate, with regard to that issue, the court had asked us to put something in writing, I believe, by Wednesday. We've been tied up with other issues. And is the court still of a mind that still do this? You know our position on the matter, and so if we're going to argue it, that's fine, we can do it later. But in view of all the things that happened and the things we have to do, is the court still of a mind to try and do that?
Yes.
All right, well, then perhaps we can have till tomorrow to put something in writing and argue tomorrow.
Mr. Byrne, what's the status of the modifications at the scene, specifically the lighting, that one light fixture that was missing or was inoperable?
We're ready to go ahead. The lighting has not been changed, so they've looked into that and taken care of it. They have paperwork to back it up as well that the lighting, street lighting has not been changed.
Interesting.
Well, you'll entertain, before you make a final decision,
Yes.
I want to get it back on calendar because we think that we have some cogent arguments you may want to listen to regarding this is not necessary and the overall costs and that sort of thing, especially if we've got to make adjustments with the scene. But I'd like to argue that at the appropriate time. Or have
Okay.
Mr. Scheck argue.
Tomorrow?
You just say that the light bulbs are the same as they were
I think he's indicating street lighting.
Street lighting up.
Yeah. Street lighting. Bundy.
Mark, you want me to see, how do you want to handle it? You want us to put it in writing, or you want us to...
I want your objection specific. I mean, there were specific, discrete things we looked at Sunday night. We looked at low voltage lighting. We looked at high voltage lighting. We looked at shrubbery. We looked at overhead street lights. We looked at views from across the street. We discussed which photographs were relevant. We discussed many things. So organize it, put your thoughts in writing, give it to me tomorrow morning.
Right. The only thing that I want to mention in that regard is that
Well-
in terms of how you want to proceed on that, you had indicated that if there were going to be changes made, that you wanted to go out again to take a look, particularly at the Bundy location, to see if we could do it so a second jaunt might be required. Is that still your
I think that's implicit.
Okay.
All right. Any other issues we can resolve while we still have some court time? All right, counsel, thank you. We'll stand in recess then until 1 o'clock. All right. 5 o'clock, Dave. Yeah, thank you. In the Simpson matter, all parties are again present. The jury is not present. Counsel, I just wanted to ask a couple of scheduling questions before we return to Michele Kestler. My recollection of some of our discussions earlier today and yesterday was that after Ms. Kestler, the defense wanted to present the testimony regarding from Ms. McKinney and related items, correct?
Yes, I believe that is correct, Your Honor. We had tried to, so we wouldn't have any downtime, I had tried to arrange for Mr. Weitzman, who's unavailable until the first of the week. As you may know, we're going to have this officer from Chicago, Officer Barris, the officer who recovered. It may or may not be necessary to have the officer recover the glass, which is now out here in the glass and the bloody towel. Then we have Menzione, and then there's a fingerprint man from the LAPD. As you know, Mr. Simpson's fingerprints weren't found anywhere, and we want to call Aguilar, I guess his name is. Aguilar, Menzione, perhaps from Chicago, Barris from Chicago, Howard Weitzman, who won't be available till the first of the week. And then, of course, we pushed back Mr. Regal. And then we have, but so the next up would be Ms. McKinney, because she's here from North Carolina in addition to that. So that's kind of where we are, and I don't know if we're going to have any downtime, but I was working over the lunch hour trying to see who else we had now. Perhaps the fingerprint person, the other people it was going to be hard to get before the first of the week.
I was about to say, because obviously, given our late start today for reasons beyond this court's control, we may not, I hope to at least finish Ms. Kestler today. Assuming we can do that, I hate to lose any more court time with the jury since we lost an entire day yesterday. So
Sure.
what my inquiry is there anybody after Ms. Kestler that we can perhaps the prosecution can assist you in getting available, for example, the fingerprint person or somebody like that?
We would like to talk to Detective Lang, and we'd like to talk to Mr. Aguilar. The others, I just can't. I called Howard Weitzman today. He's involved in some new ventures, and he won't be available, if at all, until the first of the week. The detective now can't come to the first of the week. And I think the problem with Menzione is the same, but I think with Aguilar, if we can talk to Lang, that might be helpful. So that's what they can help us with Lang, possibly Van Adder, and Aguilar, I would think. And we'd have the McKinney matters.
Okay.
All right.
Because as I indicated to you, that I think the soonest that I'll be able to review the materials on the McKinney issue will be by Monday morning. So, it's getting.
We're going to need until Monday morning, I think, to file a response.
No, I understand that.
to the moving papers.
I understand that.
The
And
fingerprint
I'm sorry.
witness is here in the
We do
building.
want Furman too. I'd asked for Furman yesterday, so we want Detective Furman back here. So,
What day?
well, depends what the court, I suppose that Monday will be soon enough now, given where we are, by Monday.
So can we inquire after Michele Kestler is back tomorrow?
Well, if we can get Aguilar, it's an LAPD witness.
He's upstairs in my office now. We just say when we want, and they'll.
Okay.
And after Aguilar?
Tomorrow morning. Mr. Aguilar will be here tomorrow morning. Yeah.
We might want to talk to him this afternoon. We'd like, if possible, if Detective Lang's in the building, Lang or Van Adder, to talk to him this afternoon, which might save some time. We have a couple of questions to ask them. We can talk to them, it might save some time. And then I think that's...
Are they available, or is something we can talk to them over the next break?
They're upstairs eating donuts, as I understand it right now, Your Honor. So if someone wants to talk to them, we'll have them come down.
We'd like to talk to them if we can. That's pretty much
Okay,
it.
then you can chat with them at the break and see if we can...
Lang, Van Adder, and then and Aguilar, but we still wouldn't have enough to fill the day, if that's your question. But don't you have lists of them tapes anyway, Judge?
I have to, but the problem is, I can do that on my own time.
Yes.
I'm concerned about putting the jury on ice again.
Sure.
And, you know, as I expressed to you this morning, I'm concerned about the durability of this jury.
And we are too, Your Honor. Let's proceed with Ms. Kestler. Let me look at our list, and let's see where we get today, and let me talk to you back about it at the end of the day.
All right.
Because it's important also, we want that brief for you. There's a number of things as you always say, Judge, we've got a lot of things that are coming together all at once here.
But
so
you
we're
got a
trying to-
lot of lawyers, too.
Well, yes, but they can only do so much, but we're going to get it done. All right?
Well, I seem to manage to stay up with you, so...
You do, Judge, and you should be complimented for that. I was particularly impressed with all those transcripts you had out in there. Did you put them all back now, I hope?
I was packing them up.
Good.
All right.
Your Honor, one additional issue, if I may.
Yes, Mr. Darden.
This morning, when Mr. Neufeld asked the court's permission to declare Ms. Kestler an adverse witness, she has indicated to me that during that July 13 conversation with defense counsel, she did not tell them that she resented them. In fact, she told them the exact opposite. She did, however, tell counsel that she realized that they were only doing their job, but however, she felt that at times she thought that they were rude and unprofessional in their demeanor and in the manner that they treated witnesses, as I understand it. But she specifically told them she didn't resent them, and then she understood that they were only doing their jobs as defense attorneys. So I'd like to clear the record on that issue.
All right. But as I've indicated to Mr. Neufeld, that if we get to the point where he feels that's appropriate, then he needs to approach first. But, and I also indicated I'd allow some leeway in use of leading questions for foundational purposes and in getting to particular locations, because that seemed to be the problem in getting to specific dates and times. All right, let's have the jury, please.
I can be here at 9 o'clock.
Yes. Um, 3:30-ish.
Concerning the late print lists, and I indicated that if they would put it in writing, I probably would. But I haven't seen anything yet, so I just want to take this opportunity to remind the defense to give me something in writing.
Okay. Ms. Clark was indicating a willingness to stipulate to latent print issues. So, perhaps,
We'd be glad to talk about that. Let me ask you another question, too, man.
be my guest.
We talked about the foundational issues, Your Honor, but I think we still need him for the results.
I spoke to Carl Douglas about this last week, and he indicated to me that he wanted me to stipulate to people who lifted the press.
All right.
Yes, just put it in writing if you want. And that's all.
seated. Let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. First of all, let me thank you again for your great endurance and patience with us. As I mentioned to you yesterday, that there was a possibility that we would have a delay getting started this morning, and that's why I left you to sleep in a little this morning over at the hotel. And as luck would have it, when we got started or wanted to get started at 1 o'clock this afternoon, there was a security problem in another part of the building this afternoon that kept us from getting started, and we were all sitting here waiting, and we just, for reasons that are beyond our control but have nothing to do with this trial, we just couldn't get started. And as I mentioned to you yesterday, but I don't think I can say it to you enough times, always in the back of my mind, I'm aware that you're either back there or upstairs or at the hotel. And I'm always aware that we're taking your time, and that court time not spent dealing with you is, in your minds, wasted time. And I understand your frustrations and concerns that we don't spend more time presenting evidence to you. By the same token, I think you know that this is a very long and very complicated case, and there are many complicated legal issues that I have to deal with every day regarding what evidence will be presented to you. And unfortunately, some of those hearings I can't take care of in 20 minutes. You've probably learned by now that I'm a very optimistic person. I always think I can do something in 20 minutes. That winds up taking me an hour and a half to do as far as resolving some of these issues, and for that fault I apologize to you. But I think if I stay optimistic, hopefully we'll finish this case soon. Please bear with us, and on behalf of both parties, I thank you for your patience in this matter. Ms. Kestler, would you please resume the witness stand, please? All right, the record should reflect that Michele Kestler is on the witness stand, undergoing direct examination by Mr. Neufeld. Good afternoon, Ms. Kestler.
Good afternoon, Your Honor.
And you're reminded that you were still under oath. Mr. Neufeld, you may continue.
Yes, Your Honor.
Good afternoon, ladies and gentlemen.
Good afternoon.
And good afternoon, Ms. Kestler.
Good afternoon.
Ms. Kestler, when we left off, I guess it was Monday, I had asked you some questions concerning the extent of your involvement in this particular case.
Oh, thank you.
And I asked you about your participation in certain meetings, and if you recall, you said that you didn't recall some of them. Is that correct?
That's correct.
Let me just have this marked for Exhibit 1317, next in line, 1317. And these are handwritten notes of Gregory Matheson. I'm just going to ask you to take a look at them and to see whether they refresh your recollection as to your participation and attendance at those meetings that I mentioned to you when you were last on the witness stand.
I'm sorry? All right, at sidebar with the court reporter, please. You may. All right, Ms. Kestler, if you'd look at that item 1317, specifically the highlighted markings, and see if that refreshes your recollection. Just read it to yourself and see if that refreshes your recollection as to any of the meetings that we discussed on Monday afternoon.
Well, these are the, just a minute. Well, most of these I'm familiar
Hold on.
with.
Okay. Pose the question.
Ms. Kestler, having looked at those notes of Mr. Matheson's, and in particular the highlighted areas,
Yes.
does that refresh your recollection as to, for instance, whether you participated in a meeting about this case on June 15th with Marcia Clark and other members of your criminalist laboratory?
Yes, I didn't know the date, as I recall, was June 15th.
And so now your recollection has been refreshed?
According to, based on the notes, yes.
Okay. And
Ask her some questions about what the notes are.
I'm sorry, Your Honor.
Foundation, whose notes? Does she recognize them?
Oh, do you recognize whose notes these are?
I believe they look like Mr. Matheson. It looks like Mr. Matheson's writing. I'm not.
Okay.
And it has L numbers on it, so that would have been provided by the laboratory, so I presume it came from us.
Well, all I'm asking you, Ms. Kessler, is whether or not now, having looked at those notes, does that refresh your recollection that you did participate in the meeting on June 15th with other members of the criminalist laboratory and the Deputy District Attorney, Marcia Clark, concerning what to do with certain items of evidence?
It refreshes my memory as to exactly what it says here, that what we were going to do with, I don't recall which items.
But with some items of evidence?
Some items.
Okay. And having looked at those notes, Ms. Kessler, does it refresh your recollection that on the very next day, June 16th, you participated in another meeting about this case with Mr. Yamauchi and Dennis Fung and Aaron Riley to discuss, and others, to discuss security measures for this particular case?
Well, the only security measures...
I'm sorry, Ms.
I'm
Kessler.
sorry.
All I'm
Yes,
asking whether or not, having looked at the notes, does that refresh your recollection that on June 16th, you did participate in a meeting to discuss security?
It wasn't really a meeting. It was a discussion, but yes.
Okay. You participated in discussion on the issue of security. All right. And having looked at those notes, does it refresh your recollection that on June 21st, you participated in a discussion with Mr. Fung and Mr. Matheson and Mr. Yamauchi regarding analysis and other generated requests concerning evidence in this case?
Yes.
And by the way, approximately how many, and by the way, those are all meetings that were held or discussions held just in the first week about this case that you participated in. Is that correct?
Yes.
Okay. And approximately how many crime scenes are processed by your laboratory in a year, or in the last year, for instance?
Sustained.
About how many cases did your laboratory handle last year?
Now, are we talking about crime scenes?
Yes.
Okay. Crime scenes, as far as the criminalist going to crime scenes, or the entire laboratory?
Oh, in terms of cases in which your laboratory became involved initially because it was a crime scene that had to be processed, and then items were brought back to the laboratory and analyzed?
Okay, for criminalists only, right?
Yes.
Okay. Probably about 400.
Okay. And of those 400, how many cases did you personally sit down for perhaps a half a dozen hours straight, personally analyzing or examining items of evidence of those 400 cases?
Overruled.
Well, I didn't personally examine anything this first week either.
I'm just asking you, of those 400 cases, putting this case aside, how many of those cases did you personally examine items of evidence for several hours at a time?
Well, none, including this one.
Well, on June 29th, 1994,
Okay.
weren't you present with Colin Yamauchi and Greg Matheson in your office for the examination of many items of evidence in this case?
Yes, I thought you were referring to this first week that we were discussing earlier. But yes, I was.
Right. And, well, the first week, second week, or any week, Ms. Kestler, how many of those other 400 cases did you personally participate in the examination of items of evidence which took several hours?
Overruled.
I don't know if I can answer this the way you want it, because I personally participated in the field in some of the collection of evidence in some of these cases. I don't know if that would be included, and then later the review of some of that evidence.
In this
Would that be included?
Let me clarify it for you.
Thank
In this
you.
particular case, you spent approximately 7 hours, would that be a fair estimate, on the afternoon and evening of June 29th, 1994, examining items of evidence in this case with Mr. Yamauchi and Mr. Matheson?
Overruled.
We did an inventory of the evidence, if I could use that term, and it took
Fine.
several hours.
Several hours. I think, would it be fair to say that you started about 2 or 2:30 in the afternoon?
I believe so.
And you went till about 9:30 in the evening?
Probably.
Okay. Now, my question is, on how many others of the 400 cases that your laboratory processed in the last 12 months did you spend 7 hours back in the laboratory personally inventorying the evidence in the case?
I didn't, and
This would be the only case?
yes.
Okay. And, in fact, not only did you do that on June 29th in this case, isn't it also true that on August 26th, you personally collected evidence in this case at the Bronco?
Overruled.
Yes.
And on August 26th, Ms. Kestler, when you personally collected evidence in the Bronco, where was the Bronco?
I always get this wrong, so let me look at my notes, if you will. I can never remember the name. Keystone Tow in Van Nuys.
And now, just so I'm clear on this, the Keystone Auto Garage where this occurred, that's not a public place, is it?
I don't know. You mean, is it used by anyone else?
No, I'm sorry, I apologize. The Bronco was kept in a secure area at the Keystone Garage, is that correct?
Oh, yes.
Okay.
That's correct.
And unlike the time when evidence was collected by criminalists in this case at Bundy and at Rockingham, this was in an enclosed area at the Keystone facility, was it not?
Yes.
In other words, the media couldn't stand there and simply take pictures from the sidewalk or from the street, could they?
No, they could not.
Now, and you, namely the SID unit, the criminalist laboratory, ran that that inspection of the Bronco on August 26th, didn't you?
Sustained.
Okay. Was the visit to the Bronco on August 26th done for forensic purposes?
Yes.
Okay. And when you did that on the 26th, isn't it true that a photographer from Life magazine was permitted to be present during that outing on the 26th?
Oh,
I believe that's where he was from, yes.
And in fact, during that time while you were collecting evidence at the Bronco in this secure yard belonging to the Keystone Company, were there times where you personally were actually posing for pictures for the Life magazine photographer?
No,
overall, natural stand. Are you going to offer any of these photographs?
Not through this witness.
All right. Let's proceed.
Is it a normal practice when members of your laboratory that you direct are collecting evidence, not in public places but in secure areas such as the Keystone Garage, that media photographers are permitted to be present to photograph what happens?
could you repeat the question?
Is it a normal procedure for the SID unit, for the criminalist laboratory that you are the director of, to permit media photographers to be present while you are collecting evidence in a murder case at a secure, non-public facility?
No, I have never permitted it.
So in your days as the, by the way, before you were named the director of the laboratory, how long had you been the assistant director?
Since 1982, one of the assistant directors.
Okay. From 1982 to the present, other than this case, has there ever been a single instance where criminalists from your laboratory were collecting evidence at a secure, non-public facility where a magazine photographer was permitted to be present to photograph the collection of evidence?
Not to my knowledge. I have never personally permitted anyone, including in this case.
Well, when the magazine photographer showed up, did you tell him that he wasn't permitted and therefore had to leave?
I asked him, and I was told that that was approved by a higher authority than me.
And so you did not do anything to try and alter that situation?
There was a little I could do at that point.
Okay. Were you, to your knowledge, who was the higher authority that authorized this?
Chief of police.
And you made no attempt to call the chief of police to explain that it would not be consistent with your policies and procedures to have that magazine photographer present?
Well, once I'm ordered by the chief of police to do something, unless it's really, I know he'd been doing other things on this case, so it's not something I would question. And he had someone with him, and he was directed by that individual as what he could do and what he couldn't do.
Was the chief of police present for this particular criminalist outing?
No.
Now, at some point in time, in June of 1994, or July of 1994, did you have a discussion with Dennis Fung concerning the fact that Andrea Mazzola was named as the officer in charge on some of these crime scene forms?
I don't recall when I had a discussion with Dennis Fung, but several of us had a discussion with Dennis.
And when you had that discussion with Dennis Fung about this particular matter, did you advise Dennis Fung that it would not look very good if it came out in the grand jury that Ms. Mazzola was, who was a trainee, was seriously involved in this case?
Hearsay, Your Honor, objection.
Sustained.
Well, at the time that you met with Dennis Fung and had a discussion concerning Ms. Mazzola being listed on the crime scene form as the officer in charge, was it a concern to you that this might get out, namely that she was a trainee and listed as the officer in charge?
No.
Now, prior to you taking the witness stand in this case, were you interviewed by Mr. Scheck and myself?
Yes.
And did that meeting occur at the office of the counsel for the city of Los Angeles?
Yes.
And was it true that the only way you would agree to meet with us before you testify was with your counsel present? Is that true?
That was not at my, partly I was concerned, but part of it was the city attorney wanted to be there.
Are you saying, Ms. Kestler, that you don't have the ability, the authority, the discretion to meet with lawyers from the other side without counsel present, should you decide to?
I do to some extent, but when they advise me that they'd like to be there, they're the attorney, so I usually take their advice.
So you took their advice and you decided that you would only talk to us if the attorneys were present?
That's correct.
Now, has members of the district attorney's office wanted to speak with you before you testified today?
Yes.
And have you spoken to them?
Yes.
Have you spoken to Mrs. Clark?
No.
Have you
I
spoken?
except to say hello. Yes, I did say hello to her.
All right. Well, have you spoken to Mr. Darden?
Yes.
And you've spoken to Mr. Goldberg, haven't you?
Yes.
And when you met with Mr. Goldberg from the district attorney's office and you met with Mr. Darden from the district attorney's office, did you always have counsel from the city present?
Sustained.
All right. When you met with Mr. Darden to discuss this case, did you have counsel from the city present?
No.
When you met with Mr. Goldberg each time, did you have counsel for the city present?
No.
And at that meeting where Mr. Scheck and I interviewed you on July 13th, didn't you say at that time that, didn't you say during that meeting that you were concerned with the fact that Andrew Mazzola was listed on the reports as the officer in charge?
Yes, but that's a different question than you asked me earlier.
Okay.
My interpretation of your question, if I may
I'm
interpret
sorry, Your
it.
Honor.
Well,
I'm just
I wanna
asking,
make-
I'm asking, right now I'm asking if you did say that on July 13th. Is that correct that you did say that to us, ma'am?
I'm asking you, are you asking me, did I say I was concerned, or was I concerned that it got out?
I'm asking you now, did you say to us on July 13th that you were in fact concerned with the fact that Andrea Mazzola was listed on these crime scene sheets as the officer in charge?
You can answer the question.
Yes.
Okay. Now, let me go back. And ask you a few questions about your own training for your current position, ma'am. Before joining the Los Angeles Police Department, did you work in the public sector or in a private laboratory?
I worked in private industry in a laboratory.
Okay. And what year did you join the Los Angeles Police Department?
1976.
And when you worked in the private sector, in a laboratory, did any part of your work concern serology?
No.
Did any part of your work concern DNA?
No.
Did any part of your work concern the methods for collecting and preserving bloodstain evidence?
No.
Now, you're the chief criminalist in a unit of approximately how many criminalists?
Approximately 50 currently.
And I take it you consider yourself a scientist, don't you?
Yes.
Would you agree that one of the ways that people in science advance is through publication of their research?
If not necessarily research and not necessarily publication, that's one way to do it, yes.
Well, I'm only asking you whether that is one way.
That's one way.
Okay. And how many articles have you personally authored, in the last 20 years?
Just one.
And that one article that involved illegal drugs or illegal drug laboratories?
Yes.
Have you ever authored any article at all on DNA typing?
No.
Have you ever authored or collaborated on any article on conventional serology?
Sustained. She said she had one publication.
Would you agree, Mrs. Kestler, that if you are managing a discipline, okay, or a certain program in the laboratory that you yourself may not be an expert in, that it's important to have people with appropriate qualifications running that program as your subordinate?
Sustained.
Well, you mentioned that it was during the time that you were the assistant laboratory director that a DNA program was implemented at your laboratory. Is that correct?
That's correct.
And would you agree, Ms. Kestler, that proficiency in molecular biology is certainly an area of science which is relevant to forensic DNA typing?
Well, you can answer the question.
Yes.
And as the assistant director of this criminalistics laboratory at the time that the DNA program was created at SID, did you go out and hire somebody with a doctorate, a PhD in molecular biology to help set up the program?
No.
Now, after you set up the DNA program at the LAPD SID, did you...
Sustained.
Did you, as the assistant director of the SID Criminalistics Laboratory, play a role in helping to set up the DNA program?
You'd have to be more explicit than that. What role? More a managerial role.
Exactly. Did you play a managerial role in helping to set up that program?
It's hard for me to say. I would say yes at this point, but I'd like you to be more explicit if you could.
Okay. Well, in other words, just so I understand you correctly, ma'am, you're saying that you did play some managerial role in the creation of the DNA program at the LAPD.
I still don't understand. I don't really understand your question. I have trouble answering that. It's
Okay.
just a flat yes.
Well, what does it mean to you when you say you played some managerial role in the creation of this program?
What it means to me is that in creation of that role, or in that role, I played the part where I listened to my people, I looked at what they were doing as far as what was required from Twigdam. I ensured that they were sent. One of the people that was in fact in charge of setting up the program went to the FBI for several months and in fact did research for them under their DNA program, and, if you will, was blessed by the FBI to do DNA and came back, and that individual, under the guidance of supervisors who also went to classes in DNA, and came back and set up the program.
Okay, so you managed the people who undertook all those efforts that you just described. Is that correct?
That's correct.
And it was your decision, in a sense, as the manager, to send all those people to the FBI and other places to get the training that you deemed appropriate. Is that correct?
Right, and I also looked for insight from them and other managers as to what programs would be good for them to attend.
Did you bring in a single outsider with a PhD to evaluate your program once it was set up, but before you actually took on casework?
Not really brought into the laboratory, but via the fact that the FBI looked at what our individual people were going to do before they did it. So they didn't actually visually come in and see the facility, but they looked at how we were going to do it.
I'm not asking you about the FBI and FBI agents. What I'm asking you about, Ms. Kestler, is did anyone who has a PhD in this area come visit your laboratory and inspect the setup, okay, and give it that type of critical examination in person before you actually went online accepting cases?
I'm not sure that the people that came actually physically into the facility had PhDs. I do know that the person that we consulted with the FBI was not an agent, and yes, he did have a PhD.
I asked, but did that person come and visit
No.
the laboratory and inspect it?
No, I'm not trying to make that point.
All right. Now, would it be fair to say that it would be one of your desires as both the assistant director since 1982 and more recently the director of the criminalistics laboratory to make it a modern and scientifically advanced laboratory?
I feel we would always like to stay a modern laboratory. We are modern in our techniques, if you will. Unfortunately, some of our facilities are not brand new.
As a laboratory director in the state of California, are you familiar with the manner in which various crime laboratories are run throughout the state?
Oh,
If you could be specific,
Well, let me ask you this. Do some of the crime laboratories have a civilian head, whereas other crime laboratories have a head who is a sworn police officer?
oh,
that's my understanding, yes.
And your particular laboratory, the SID division, is not run by a civilian. It's run by a sworn police officer. Is that correct?
Sustained. Phrase the question.
Okay. The Scientific Investigation Division of the Los Angeles Police Department does not have at its head a civilian, does it?
As of this week, yes, it does, but no, prior it did not.
Okay, and during the investigation of evidence in this case, the head of the laboratory was a police officer, is that correct?
No, the head of the laboratory, I'm the director of the laboratory.
I withdraw that. The head of the Scientific Investigation Division of the Los Angeles Police Department was a police officer, is that right?
That's correct.
And what is his or her name?
His name still is Captain Brad Merritt, but he's no longer there.
All right.